Good evening. My name is Roger Traves, and thank you for joining us. And welcome to this webinar, Appeals: When is a Trial Judge Wrong? The topic is intended to promote discussion of the nature of and the limitations on appellate review and a comparative analysis of the law in the United Kingdom and in Australia. But first, I should introduce our speakers. We are very privileged indeed to have with us the Right Honourable Sir Richard McComb, Lord Justice of the Court of Appeal of England and Wales. Lord Justice McComb was called to the bar at Lincoln's Inn in 1975 and was appointed Queen's Counsel in 1989. He was appointed to the High Court in 2001, where he served on the Queen's Bench Division. In 2012, Sir Richard was appointed a Lord Justice of Appeal and to the Privy Council. He has agreed to provide for us a perspective on the scope of appellate review in the United Kingdom, and there is no one better placed to do so. Lord Justice McComb has a particular penchant for languages. He speaks no fewer than 6 of them. Thank you so much, my Lord. I've always wanted to be able to say that. Thank you so much, my Lord, for agreeing to participate in this webinar. It's no coincidence that we have with us this evening, not only you, but almost 400 registrants.
Roger, thank you very much. It's an honour to be asked. It's an honour to be asked, and it's lovely to travel 16,000 kilometres to the Australian sunshine.
Thank you very much, Judge. Mohammed Jameh Hafiz Baig is our other speaker. Jameh is a barrister in our chambers at level 27 here. He practices in commercial and public law, encompassing a wide range of subject areas and experience. Jameh holds a Bachelor of Laws with first-class honours from the University of Queensland and a Master of Laws from that same university. He holds a university medal. He holds a Bachelor of Civil Law with distinction from the University of Oxford. Jameh is co-author of the forthcoming Federation Press book, The Law of Tracing, and he's a former associate to His Honour Justice Keane AC at the High Court of Australia. Thank you, Jameh, for agreeing to present for us this evening.
Thank you, Roger.
In the decision of State of Queensland and Masson, delivered by the High Court recently, the High Court restored the decision of the trial court that an ambulance officer did not act negligently in the treatment of a young woman suffering from acute asthma. Sadly, the woman suffered irreversible brain damage after a terrible attack, and she died many years later, but not after a significant amount of time and money, as well as the love of her parents and relatives had been spent with her. The proceedings were brought by her estate against the State of Queensland, and the case ultimately turned on whether the oral evidence of the treating ambulance officer should be accepted in the face of an earlier written statement by him, which was, on one view of the statement, inconsistent with his oral evidence. The trial judge accepted the oral evidence, having watched the witness carefully. The Court of Appeal, in overturning the decision of the trial judge, found the oral evidence inconsistent with the written statement and preferred the evidence from the earlier written statement to the oral evidence of the witness. The High Court reinstated the decision of the trial judge and found that the appeal court had acted beyond its appellate role by failing to have due regard to the opportunity of the trial judge to observe and hear the witness and to form a view based on his assessment of the witness's credibility. The decision is a reminder to us all about the limitations of appellate review in respect of factual findings of a trial court, particularly in circumstances involving oral evidence and findings by trial judges based on the observations of a witness. Masson was a case involving an appeal on findings of fact. As we shall see, the scope of appellate review depends on the nature of the decision being challenged. Appeals are characterised by attention. On the one hand, appeal courts have functions that they're required by statute to discharge. Appeals serve both the public interest in the creation of guidance for the lower courts and in the correction of errors, and they serve private interests by the correction of errors in particular cases. On the other hand, appellate courts must observe the natural limitations that exist in an appeal proceeding wholly or substantially on the record, and must give due respect to the advantages enjoyed by the trial judges. Those limitations, which are recognised in the authorities, include that the appellate court will not have seen the witnesses or have been able to assess their credibility, that the appellate court reading a transcript cannot fully share the feeling of the case that we all have when we sit through it. The appellate court does not usually have time to read all of the evidence of the trial, and nor is the appellate court ordinarily taken to all of the evidence. Finally, the appellate court does not usually have the benefit of an extended period of time to reflect upon the evidence and draw conclusions from it. As the High Court said in Fox and Percy, the difficult question in this area is how to resolve the dichotomy between appellate obligations and appellate restraint. How this dichotomy is resolved determines not only how appellate courts decide appeals, but also how solicitors and counsel prepare the case and argue the appeal. The balance has been struck in a slightly different way in Australia and in England. Jamais.
Thanks very much, Roger. So the first topic we're going to discuss is the respective functions of the Queensland Court of Appeal and the English Court of Appeal. And in relation to the Queensland Court of Appeal, the starting point is Uniform Civil Procedure Rules 1999, and in particular, Rule 765, subsection 1. And what that rule tells us is that an appeal to the Queensland Court of Appeal is by way of a rehearing. Now, rehearing is one of those tricky words in the law which has a number of different meanings, and the particular meaning depends on the context in which it's used. But in the context of the UCPR and in the equivalent provisions in every Australian state and territory, rehearing has a very settled meaning and it has defined incidents. In particular, the word rehearing in this context means that the Court of Appeal determines whether there has been an error in the trial judge's decision. Despite the word rehearing sounding like the Court of Appeal conducts a de novo hearing where it considers the matter afresh, in fact, the court's task is to conduct a real review of the trial judge's reasons and the evidence, and to see if it can identify any error. And that error may be a legal error, a factual error, or a discretionary error. But the Court of Appeal cannot exercise its powers unless some error is established. Now, that error has to be established either by reference to the trial judge's reasons and the evidence before the trial judge, or by reference to any fresh evidence which the Court of Appeal allows the parties to adduce. And there's power to do that in Rule 766. And if the Court of Appeal is satisfied that an error is established, it is required to give the judgment that it considers ought to have been given in the court below, and it has all of the powers of that court for that purpose.
Thank you, Jamais. Lord Justice McComb.
Thank you, Roger. Thank you, Jamais. The reference in your materials to the civil procedure rules from England and Wales are of importance because they reflect a change in our emphasis, if I put it that way, in the approach to appeals that took place in the 80s and 90s because of the huge pressure on the lists in all the courts, in particular the appeal courts. We got rid of, rightly or wrongly, the right to appeal from a final order, and you always had to get leave, or as it's now called, permission, to go to the appellate court. In the civil procedure rules, the rules specifically changed the emphasis of the criterion for, or the nature of the appeal hearing to one of review rather than rehearing, which was the word used in the old rules of the Supreme Court in 1965 as amended. Now, if you care to look it up, you'll see that an appeal before us is now always a review. And that has meant that there's been a slight shift in emphasis. The early cases, if you look, for example, at the one that's cited in your materials, E.L. DuPont, Lord Justice May said at one end of the spectrum, there will be decisions of primary fact reached after an evaluation of oral evidence where credibility is an issue, and purely discretionary decisions. Further along the spectrum will be multifactorial decisions, often dependent on inferences and analysis of documentary material. There have been several cases since, up to 2016. Justice Sales said in a case called Smetch Properties, that the appeal, the task of this court is to ask whether the judge had legitimate and proper grounds for reaching the decision she did, rather than simply for this court to approach the matter completely afresh and make up its own mind without regard to what the judge decided. So the emphasis, if I put it that way, has somewhat changed between the rules of the Supreme Court, those early cases, and now very much the emphasis being on the nature of a review hearing as the civil procedure rules provide. Roger.
Thank you, Sir Richard. Having heard from Lord Justice McComb and from Jamais, it's clear that there are a number of similarities in the procedures adopted by the two courts. A rehearing in the Queensland Court of Appeal and a review in the English Court of Appeal are both procedures for the correction of error. In each case, the appellate court considers whether the trial judge erred by reference to the evidence before the trial judge and any additional evidence or fresh evidence adduced with permission. Neither procedure involves what might be called, frequently is called, a rehearing de novo, where the appellate court considers the matters afresh, where the same witnesses and further witnesses might again be called, as if it were before the court for the first time. The important point, at the risk of belabouring it, is that the appeal barrister, the legal team, must point to error on the part of the judge. It's not infrequent that submissions will commence with the proposition, Your Honours, these are the errors to which we point. And it's a fair question for the Court of Appeal when the matter is first called on to ask, indeed, what are the errors? It's not a matter of simply asking the court, would you come to a different view? That said, though, what amounts to appellable error, that is, what sort of errors can be the subject of appeal, can't be determined without directing attention to the nature of the decision, which is the subject of the appeal. And there are four types of decision which are relevant here. First, findings of fact, of which Masson was one example. Secondly, determinations of law. Thirdly, discretionary decisions. And fourthly, decisions known as evaluative decisions. Each of these decisions carry with them separate tests and considerations when determining whether or not there is an appellable error to which a party might point. We'll deal with each of those in turn. Jamais, I'll ask you to start. Thank you.
Thank you, Roger. So the first of the four types of decisions is what we've called findings of fact. And an example of that is where in the trial court, there's conflicting testimony between two witnesses and the trial judge has to decide which witness is to be believed on a particular point. Another example is where a witness gives testimony which conflicts with contemporaneous documentary evidence, and the trial judge has to decide whether to believe the witness or whether to believe the documents. That's another example of a finding of fact. And in Australian law, the High Court has adopted quite a strict standard for overturning such findings of fact. And in particular, I'm referring to those findings of fact which are affected by the trial judge's impressions of either the reliability or the credibility of witnesses. And in a series of decisions, the most important of which is Fox and Percy, which will be on the list of citations, the High Court has said that there are really only three circumstances in which a court of appeal should ever overturn findings of fact of this type, i.e. of the type that are affected by having seen the witnesses. And the first circumstance is where the findings are demonstrated to be wrong by incontrovertible facts or uncontested testimony. The second is where the findings are glaringly improbable. And the third is where the findings are contrary to compelling inferences. And those three categories have been reaffirmed time and time again by the High Court in recent years in the Robinson helicopter case, in Lee and Lee, and most recently in the case with which Roger opened, Queensland and Masson. And importantly, in a case called Lee and Lee last year, the High Court made clear that the appellate restraint which is required doesn't just extend to primary findings of fact. It also extends to secondary findings of fact, which are based on a combination of the trial judge's impressions and inferences from other primary facts. And the example which the court gave, with which you'll all be familiar, is in cases involving unconscionable conduct, in the Amadio sense. And what the court said was that proof of the interplay between the dominant and subordinate position in a personal relationship depends on A, inferences drawn from other facts, and B, an assessment of the character of each of the parties. And so that's a finding of fact, which isn't a primary finding of fact, it's a secondary finding of fact. But the appellate restraint still applies because it's a finding of fact which is affected by the trial judge's assessment of the witness's credibility or reliability. And that's really the important point.
Thank you, Jamé. Lord Justice McComb, appeals against findings of fact in the UK.
Test very similar. The threshold's very high. I was interested in Jamé's comment that there's slight merging, which I'll see in one of the references I'm going to come to, about cases where you're drawing inferences from findings of primary fact, where the matter becomes much more blurred. But the primary rule, coming strange enough from two Scottish cases, I can say strange enough, you know, we all like the Scottish cases, but they're very influential with us too. The two on your list, McGrady and Henderson and Fox, both Supreme Court decisions from Scotland. I think the summary can be taken from what Lord Reid said in the Henderson case. The appeal court should only interfere where the finding is infected by some identifiable error, material error of law, making of a critical finding of fact which has no basis in the evidence, the demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence, or the finding cannot be reasonably be explained or justified. I hope some of you might take the trouble to look at the decision of my good friend, the Lord Justice Lewison in Page and Chobani, where he puts it so beautifully graphically, and it encapsulates entirely, I would say, the approach of the English Court of Appeal these days. And just note at the outset, he says, appellate courts have been frequently warned by recent cases at the highest level not to interfere with findings of fact by trial judges unless compelled to do so. Note this bit, this applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. The reasons are many. Two of them I'm just going to give you. The trial judge, the expertise of a trial judge is in determining facts. I love this one. The trial is not a dress rehearsal. It's the first and last night of the show. And then finally, this is another frequent quotation in later cases. In making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas the appellate court will only be island hopping. Many's the time that I've sat in the court when either I or one of my colleagues has said, Mr. So-and-so, you're just island hopping, you're not seeing the whole sea. I think that summarizes precisely I'm afraid, the practical approach that we now have to take to the voluminous evidence, paper and oral, that we get to see on an appeal hearing.
I must say, Judge, an accusation of island hopping from the bench sounds like a death knell for an appeal.
Well, it's not a good start, let's put it that way.
Judge, I'm assuming that your good friend, Lord Justice Lewison, is the author of that wonderful book on the interpretation of contracts, for which there's now an Australian equivalent that he also authored.
He also got a staggeringly high first in the English tripos at Cambridge before he decided to go to the bar and do law and go to the bar.
Well, thank you very much, Judge. It appears from what you've said in respect of findings of fact that the appellate restraint exercised by the English Court of Appeal extends to findings of fact that are not based on the trial judge's impressions of credibility and reliability of witnesses alone, in fact, go further than the restraint which is generally shown by the Australian court. Would you agree with that?
I would. That's the multifactorial element that even Lord Justice May was identifying back in 2006, I think it was. And there's a quotation that perhaps give you a little bit later from Lord Hoffman in one of the cases in the mid-range between then and now. It's a question of advantage. What advantage did the trial judge have? And if we see that he or she had the distinct advantage, well, back off, unless there's the sort of identifiable error that Jamé was talking about and I was in relation to our cases.
Thank you. All right, can I turn then to the appeals from the third category of decisions, and we can deal with this briefly. but Jamais, they are appeals from determinations of law.
That's right. So the second category is really just pure questions of law. And the classic example of this sort of decision is a decision on the construction of a statute or a contract or a will. And that statute, contract, or will has one meaning and one meaning only. And if the Court of Appeal decides that the trial judge picked the wrong meaning, then they're bound to allow the appeal and to substitute their meaning. And so the standard of appellate review for these sorts of decisions is simply correctness. Either the trial judge is right or the trial judge is wrong. There's no appellate restraint involved. And I should say that's so even though they're decisions on which reasonable minds may reasonably differ. And so another example of this in the Australian context is the question of whether a particular statute is unconstitutional. And we know from the many, many split decisions in the High Court that that's a question on which reasonable minds will regularly differ. But at the end of the day, there is only one answer, one correct answer to that sort of question. Now, I would assume the position must be the same in England. Is that right, Lord Justice?
It is indeed. I don't think there's a cigarette paper's difference between us on those points, looking at the materials you've kindly given us. I was interested to note the quotation you referred to me from Justice Edelman of your High Court, who I had the honour of calling to the bench as an honorary bencher in Lincoln's Inn when I was Treasurer last year. It was great to see him. I made some comment about teenage High Court judges in Australia, which he grinned at.
All right, thank you, Germain Judge. Can we move then to the third category of decision, that is appeals from discretionary decisions? And Germain, can I ask you to lead on that, please?
Thanks, Roger. So this is where things start getting a bit more interesting. Discretionary decisions, which is the third or the fourth type of decision, generally speaking, they're decisions where no one consideration is determinative of the outcome. And usually these are the types of decisions where the trial judge has to apply broad principles to a range of relevant facts and circumstances. And so the most obvious example of this is interlocutory decisions on practice and procedure. For example, the decision as to whether allow a party to amend a pleading late in the day. And we all know that takes place by reference to the considerations set out in Aon Risk. Another example is the decision of whether or not to grant an interlocutory injunction, or a decision about whether or not to grant costs, which we all know lie in the court's discretion. And interestingly, another one which not many people think about as discretionary is the decision of whether or not to grant bail. And in Australia, it is not enough that the appellate court would have reached a different answer to the particular question. And the classic statement is in House and the King by Justices Dixon, Evatt, and McTiernan. And I think this might be one of the most cited decisions in Australian law. And what their honours said was that in order for a court of appeal to overturn a discretionary decision, the appellant has to establish one of 5 types of error. So the first is the trial judge acted on a wrong principle. The second is the trial judge allowed extraneous or irrelevant matters to guide him or her. The third is that the trial judge mistook the facts. The fourth is that the trial judge failed to take into account some material consideration. And the last catch-all category is that the trial judge's decision is unreasonable or plainly unjust, so that the Court of Appeal can infer that some error took place. But the important point is that it's not enough that the trial judge would have reached that the Court of Appeal would have reached a different conclusion. And can I add an aside? There's also a line of High Court authority which treats a little bit separately interlocutory decisions on matters of practice and procedure. And that line of authority says that where interlocutory decisions concerned with practice and procedure, and there's no question of general principle, some particular caution should be exercised in reviewing that sort of decision. And so it seems that when you're dealing with that sort of case, even more appellate restraint should be shown than the otherwise general rule applicable to all discretionary decisions.
Thanks, Jamé. Lord Justice McComb, appeals against exercises of discretion in the UK.
Again, I think one would find that the approach virtually identical to that described by Jamé a few seconds ago. And it hasn't changed. The position has been that since I was called to the bar in 1975 and continuing. No good that the appellate court might have taken a different decision itself. The same sort of criteria are applied by our appeal courts in assessing whether to interfere with the discretionary decision of a first instance judge, classically on interlocutory injunctions and the like. You're not going to get too far unless there's been some error of principle. There's one quotation which Jamé kindly picked out of the sea of authorities, if I put it this way, on this point, from Lord Justice Brooke in a case called Tanfern and Cameron MacDonald back in 2000. It would apply today just the same way. He said that the epithet wrong is to be applied to the substance of the decision made by the lower court. If the appeal is against the exercise of a discretion, the decision of the House of Lords in G&G warrants attention. In that case, Lord Fraser of Tully Belton said, the appeal court should only interfere when it considers that the judge of first instance has not merely preferred an imperfect solution, which is different from an alternative imperfect solution, which the Court of Appeal might or would have adopted, but has exceeded the generous ambit within which a reasonable disagreement is possible. And I think that would be much the same. With various nuances in the authorities, one could cite that lots more saying much the same thing, but on discretionary decisions, it's a question of really error of principle, major. It's almost a sort of Wednesbury test. I wouldn't like to use that exactly. It's that sort of approach to a discretionary decision, I would say.
All right, thanks, Judge. All right, can I move then to the fourth type of decision, and the discussion will take a little longer on this topic because it's a little more involved. The fourth type of decision for discussion relates to appeals from evaluative decisions. Evaluative decisions are decisions involving the application of an imprecise legal standard to facts as found. In England, such decisions are sometimes referred to as decisions involving the exercise of judgment, value judgments, appraisals, or evaluations. This type of decision has also sometimes been referred to as a multifactorial decision, as a mixture of fact and law, or as a kind of jury question about which reasonable people may reasonably disagree. In a case called JSC, which will be in some notes that we'll send you if we haven't already done so, Lord Justice Leggett distinguished between findings of primary fact and factual findings which involve evaluating and drawing inferences from such primary facts, though his lordship did note that the distinction was one of degree. Examples of evaluative decisions include whether certain conduct falls within a statutory prohibition on conduct that is unconscionable, or did the defendant fail to exercise reasonable care, or is the proceeding an abusive process? Australian and English courts have taken different approaches to appellate review of evaluative decisions. Indeed, it's in the field of evaluative decisions that there would appear to be the most difference between English and Australian law. Jamé.
Thanks very much, Roger. Now, I personally think this is the most interesting part of this topic, and it's the part where you can see the most divergence between what we do and what the English courts do. And to my mind, it all comes down to a different judgment as to the advantages which are enjoyed by the trial judge. And I'll explain what I mean by that in just a moment. But to start with the Australian position, in summary, there are only two standards of appellate review in Australian law. There is the standard which is applicable to discretionary decisions, which comes from House and the King, which I explained a moment ago. And there is the correctness standard. That is the trial judge's decision right or wrong? And evaluative decisions are not considered to be discretionary decisions in Australian law. And so the appropriate standard is the correctness standard. And what that means is that the Court of Appeal isn't required to defer to the trial judge's decision. Appellate restraint isn't necessary. It simply has to consider the question which the trial judge was asked to consider. And if it comes to a different view, then the Court of Appeal must allow the appeal and substitute its decision for the trial judge's decision. And in this way, it's actually a lot like determinations of pure questions of law. And the leading case on this, and one of the most important cases in appeals in the Australian jurisprudence, is a decision called Warren and Coombs. And that was about negligent driving. And the issue before the trial judge was whether the respondent had failed to exercise reasonable care. And the trial judge held that the respondent had not failed to exercise reasonable care. He wasn't negligent. In the Court of Appeal deferred to the decision of the trial judge, and it required the appellant to establish some error in the approach of the trial judge. It essentially said that it wasn't enough that the Court of Appeal would have come to a different conclusion. And that was then criticized by the appellant when they later went to the High Court. And in the High Court, the question the court posed for itself is, what duty does an appellate court have when questions of credibility have been decided and the matter which remains for decision is what inferences should be drawn from particular facts which have been found and are no longer in contest? So to put that in other words, what is the duty of an appellate court when all the primary facts have been found and the only question left is what inferences should be drawn from those facts? Or to use the language of some of the English cases, how should those facts be evaluated? And what the High Court said was that in general, an appellate court is in just as good a position as the trial judge to determine what inferences should be drawn from facts which are undisputed or which, although they were once disputed, have now been decided by the trial judge. And I think that's really the key point of difference between English law and Australian law in this particular area, is this holding by the High Court that the trial judge and the appellate court are in the same position. And the court went on to say that the Court of Appeal will give proper weight to the trial judge's decision, but if it is convinced that the trial judge has erred, that they would have come to a different conclusion, then it must allow the appeal and substitute its judgment. And if I can quote one passage for you, the court said that Acting Chief Justice Gibbs and Justices Jacobs and Murphy said the duty of the appellate court is to decide the case, the facts and the law for itself. In so doing, it must recognize the advantages enjoyed by the judge who conducted the trial. But if the judges of appeal consider that in the circumstances the trial judge was in no better position to decide the particular question than they are themselves, or if after giving full weight to his decision they consider that it was wrong, they must discharge their duty and give effect to their own judgment. And applying this to the facts, the court held there was no reason in logic or policy to treat the question of whether the respondent had failed to exercise reasonable care as one which was peculiarly within the province of the trial judge, or in respect of which the trial judge had any significant advantage. And remember that, because when the Lord Justice speaks, we'll ask, I'm sure he'll explain what the English court's approach would be to a question of reasonableness or reasonable care. But I do want to raise one more point. There was an argument which was put to the High Court in Warren and Coombs, which was that trial judges often differ and differ markedly in these sorts of questions. And for that reason, appellate courts should be shy to interfere with these sorts of decisions. And the High Court actually turned that on its head and said, that's in fact not a reason for more appellate restraint, it's a reason for less appellate restraint. Because the resolution of these questions by different appellate courts, they said, will ultimately lead not to uncertainty, but to consistency and predictability. Now, finally, to give you one more example of an evaluated decision called the Australian Competition and Consumer Commission in Verbatis, and it concerned Section 21 of the Australian Consumer Law, which prohibits conduct that is unconscionable. And that is an evaluated decision, and all members of the High Court expressly or implicitly accepted in that case that the decision is, that the standard is one of correctness. It is not the standard which applies to discretionary decisions. The Court of Appeal must decide whether the conduct is unconscionable, and if it comes to a different conclusion than the trial judge, it must substitute that conclusion. And you can see that, as with reasonable care in Warren Coombs, and as with unconscionable conduct in the Babattas case, the position the court has come to is that you are either in breach of the relevant norm or you are not. And if the Court of Appeal takes a different view, then the appeal should be allowed.
Thanks, Jamé. That was a really useful explanation. Lord Justice McComb, the situation in respect of appeals against evaluative decisions in the UK.
Well, yes, UK, I exercise caution, England and Wales here, but there we are. I think there is to be seen in the two different strands of authorities in Australia and in England and Wales, certainly a distinct difference of emphasis. Even in quoting the Australian decision, however, I think Jamé mentioned one of the High Court justices saying that much depends on whether there's a real advantage available to a trial judge or a first instance judge on questions of evaluation. And of course, questions of evaluation cover all sorts of ranges. There's negligence, there's proportionality, there's, for example, in our company law, I don't know whether you still have the same thing in Australia, unfair prejudice to a minority shareholder, for example. There's a chap called McComb who looked at evaluative decisions in overall and tried to pull things together in a case called Sprint Room, which is right at the bottom of your list of authorities back last year. But a much higher authority than that, if I might just go to what Lord Hoffman said in Biogen and Medieva in 1997, which I think does show the distinction of emphasis. He said this: the need for appellate caution in reversing the judge's evaluation of the facts is based upon much more solid grounds of professional courtesy. It is because specific findings of facts, even by the most meticulous judge, are inherently an incomplete statement of the impression that was made upon him by the primary evidence. His express findings are always surrounded by a penumbra of imprecision as to emphasis, relative weight, minor qualification, and nuance, of which time and language do not permit exact expression, but which may play a most important part in a judge's overall evaluation. It would, in my view, be wrong to treat Benmax, I interpret that's a 1955 case, taking much the same line as the Australian primary authority to which Jamé referred. It would, in my view, be wrong to treat Benmax as authorising or requiring an appellate court to undertake a de novo evaluation of the facts in all cases in which no question of the credibility of witnesses is involved. This is the important passage, I think, where the application of a legal standard such as negligence or obviousness involves no question of principle, but is simply a matter of degree. An appellate court should be very cautious in differing from the judge's evaluation. Again, there's a reference to that sort of principle still being applied, even in cases which have turned largely perhaps on a high volume of documentary evidence. In that case of Smetch and Runnymede Borough Council, which I mentioned at the outset in a different context. I think what I said in the case called Bowen back in 2018, referring to Lord Justice Sale's judgment, he said this. I said this: it seems to me that Lord Justice Sales was addressing the exigencies of reviewing a first instance judge's assessment of primary facts, even where, as in our case, the evidence before the court below was entirely in writing. All will depend on the circumstances of the case and what opportunity the court has in reality to improve and correct the overall assessment of the evidence before the first instance. As I say, that I did try to summarize the drawing a few threads together in that last case, which I won't bore you with in this meeting, a case called Sprint Room, which pulls a few threads together, I hope, usefully for our practitioners. Difference of emphasis, I think you're right, Jamé, there is that, but it'll turn in the end, both with us and with you, by the sounds of things, to questions of advantage that the trial judge may or may not have had in assessing the evidence. But Lord Hoffman's comments in 1997 were pretty strong.
Judge, Lord Hoffman's observation that it's difficult for a judge completely to segregate a finding of fact from the evaluation of findings of fact as a whole is a really interesting one, which I suspect only, well, not only judges, but judges would be in a unique position to comment upon. And as I would understand the proposition, it's that in findings, you can't completely separate the process of the finding of fact and its evaluation, that it's an iterative process effectively, which occurs all at once. And that it's artificial, I presume Lord Hoffman would say, to think that you can find fact and then move to its evaluation as if two separate steps.
Yeah, I think that's right, Roger, I may say so. And it reflects, I think, also that spectrum that Lord Justice May was talking about back in '06 of, you know, pure fact, credibility, law, and then, you know, the color spectrum shifts all the way along the line, and there'll be different advantages for a trial judge at different stages along that spectrum line. It's not easy to explain, and it's not exactly as clear perhaps as one would like, but that's what the arguments tend to turn on I've found in appeals before us, is what real advantage did the trial judge have, you know, and often there is, I mean, even in a documents case, vast range of stuff, an assessment of the persuasiveness, say, of arguments, of expert evidence on witness statements, which I had not too long ago, and questions about the valuation of a particular property, you know, which was most convincing on paper. Judge took one way. Well, you know, one might have taken a different view, but he had to assess that against the rest of the evidence upon which that expert evidence turned. And that's the sort of argument we tend to get into these days, hearing appeals day to day on all sorts of things, just like that unfair prejudice case I was mentioning right at the end, Sprint Room.
Thank you, Judge. All right, well, in summary, in respect of evaluative decisions, the difference between Australian and English law appears to be stark. Australian law, as set out in Warren and Coombs, takes the position that generally an appellate court is in just as good a position as the trial judge to decide on the proper inferences to be drawn from findings of primary fact. English law, on the other hand, takes the view that the reasons for appellate restraint in relation to findings of primary fact apply equally to findings which involve evaluating and drawing inferences from those primary facts. One way to illustrate the difference in approach is to compare two recent similar cases. The decision of the High Court in the Minister of Immigration and Border Protection and SZVFW, which I'll ask Jamay to explain, and the decision of the United Kingdom Supreme Court in R on the application of AR against the Chief Constable of Greater Manchester Police, which in a moment, Judge, I'll ask you to address. Jamay.
Thanks very much, Roger. So SZVFW, and can I start out by commending this decision to all the attendees. It's one of those rare decisions which contains a beautiful summary of this entire area of the law, and can I recommend in particular the judgment of Justice Gagler, which explains both the history and the operation of the two standards of review, two standards of appellate review, which exist in Australian law. So in brief, the facts were that a couple had applied for protection visas, had applied to the minister for protection visas. Those applications had been rejected by a delegate of the minister, and the couple had then applied for merits review in the Refugee Review Tribunal. And in the tribunal had invited the two applicants in to make submissions and to appear at hearings a number of times, and they hadn't responded. And ultimately, the tribunal went ahead and affirmed the decisions of the minister's delegate. The applicants then sought judicial review of the tribunal's decision in the Federal Circuit Court, and the ground of review was that the decision was legally unreasonable, what used to be known as Wednesbury unreasonableness. And in the Federal Circuit Court, the judge held that the decision was legally unreasonable. The minister then appealed to the full court of the Federal Court, and in that court, some attention was given to the nature of the appeal to that court. And the court held that it was incumbent on the minister to demonstrate some sort of error in the approach which the trial judge had taken to the question, of whether the administrative decision was legally unreasonable. It wasn't sufficient that the full court of the federal court might have reached a different conclusion than the trial judge, and that's very similar to the test for appeals from discretionary decisions. The court wasn't satisfied, the trial judge had erred in that way, and so they dismissed the appeal. The minister then appealed to the High Court, and the interesting issue in the High Court was what approach should the full court of the federal court have taken on the appeal. And all 5 members of the court held that the full court of the federal court should have considered for itself the question of whether the administrative decision was legally unreasonable, and if it differed from the decision of the trial judge, it should have given effect to it. And so in substance, the court was saying that it is sufficient if the Court of Appeal, if the full court, would have come to a different conclusion, and it's duty bound to give effect to that conclusion. And in fact, all 5 judges in the High Court went on to consider whether the decision was legally unreasonable, and all 5 of them held that it wasn't, which is the opposite of the conclusion the trial judge reached.
Thank you, Germain. Lord Justice McComb, the decision in R on the application of AR against the Chief Constable of Greater Manchester Police.
It's interesting you picked that one out, because I think it's Germain had his interest excited by the difference between the Minister for Immigration case and this one. This is one where McComb's homework was slightly corrected by the Supreme Court. But it was a case where the claimant in judicial review had been acquitted of rape in the Crown Court and subsequently applied for what's called an enhanced criminal record certificate in connection with his past position. He'd been a technical college lecturer, I think, and he also was a taxi driver in more exacting circumstances. He wanted to go back to that, and the rape conviction had been involved with a very sad rape acquittal, an accusation of rape against him while driving a taxi. And anyway, the certificate was issued with the rape charge and the acquittal noted on the certificate, which of course some of you may think would be a kiss of death perhaps to as far as an application for employment. Another certificate was issued, also contained the same information, and the certificate was challenged in the court of judicial review. The trial judge concluded that although disclosure of the acquittal interfered with the claimant's rights to respect private and family life under Article 8 of the European Convention, it was reasonable, proportionate, given the need to protect vulnerable persons, young students and potential passengers in the taxi. The claimant appealed. We concluded that we should only consider the issue of proportionality for itself, where we found that the trial judge had made a significant error of principle. We found that the judge had made no such error and dismissed the appeal. And the question turned again on what was the standard of review of a question of proportionality. And the Supreme Court held a slightly different inference. I don't think my homework was corrected too much, but anyway, it said the Supreme Court held that it would not be sufficient that the Court of Appeal would have reached a different conclusion. However, the trial judge's decision might be wrong because of an identifiable flaw in the judge's reasoning, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermines the cogency of the conclusion. That result, appeal also dismissed in the Supreme Court on a slightly different test of the criterion for challenge the proportionality decision that had been taken. Contrast, I see, Germain, that's interesting.
So it seems the Australian courts then, the appellate courts, will be permitted to interfere with evaluative decisions, and the appellate court permitted to substitute its own decision effectively for that of the trial court, where it takes the view that the decision is wrong. The approach in the English, in England and Wales, is more restricted, and it will be necessary to point to some identifiable flaw in the trial judge's reasoning before the decision will be interfered with. All right. We're just running a little short on time, so I wanted to move on briefly back to the decision in Masson, with which we began. And Lord Justice McComb, you recall in Masson that the ambulance officer was said by the plaintiff to have been negligent because the ambulance officer applied to the patient a drug called salbutamol while not applying instead the drug adrenaline. The ambulance service members were all given a manual which suggested in cases of severe asthmatic attacks where there was an imminent heart attack that the drug adrenaline should be applied in preference to any other drug. The ambulance officer, though, in the particular circumstance of the case where not only did the patient have a very high heart rate, but a very high blood pressure, elected instead to apply a drug called salbutamol, which is the drug that is the operative ingredient in puffers that asthmatics use on a day-to-day basis. Unfortunately, the result was a disappointing one. But by the same token, there was found to be, by the trial judge, a reasonable body of medical opinion which supported the use of salbutamol in those circumstances. The question became one, as I mentioned earlier, whether or not the ambulance officer had considered the use of adrenaline as the manual that ambulance officers had been given required that he do. He said in his oral evidence that he did consider the use of adrenaline, but then applied salbutamol in the particular circumstances. An earlier statement that he'd made, albeit one 7 years after or 5 years after the incident and some years before trial, on one view suggested he didn't consider adrenaline at all, but thought that the manual meant that he couldn't, in fact, apply adrenaline in the circumstances. The trial judge accepted the witness's evidence that he did consider the use of adrenaline, but the appeal court overturned that decision on the basis that the earlier or prior statement suggested that he thought, in fact, at the time he was precluded from the use of adrenaline. The High Court overturned the Court of Appeal's decision, finding that the Court of Appeal should have had greater deference to the advantage of the trial judge in assessing the credibility of the ambulance officer when he said he did indeed consider using adrenaline on the patient. Do you think Masson would have been decided any differently in England and Wales? Do you think the appeal court would have been similarly constrained as the High Court found it should have been in Masson's case?
I think, Roger, the decision in England would have been exactly the same. For the sort of reasons I've been trying to adumbrate. It was a classic case of a judge assessing the evidence overall, assessing what judgment that ambulance driver, paramedic exercised on the scene. He took a view, and I think it would be very difficult for an appellate court properly to challenge or reverse that on an appeal. And it's very similar in a totally different context to the type of result that was reached in Henderson and Foxworth about what was the consideration for a particular bargain. Was it an undervalue or not? And the Lord Ordinary in Scotland decided one way, the extra division of the Court of Session decided differently, and the inner house of the Court of Session, I should say, and the Lord Reid, Scottish Supreme Court judge, said no way. The trial judge was entitled to reach the decision he did. Very similar approach in a very different context, but I think your case of Masson would have been decided precisely the same way by our Supreme Court if the same had happened in our Court of Appeal.
Thank you, Judge. All right, we just have a moment left. Can I just call on the host now at level 27 Chambers? I see there are 2 questions which have been lodged.
Yes, thank you very much, speakers, and thank you, Roger. So, well, there's actually 3, but the 2 sort of most pertinent ones is, my question is whether the principles discussed today apply equally in the federal jurisdiction, i.e. Federal Court and Federal Court of Australia, and I presume the Supreme Court in the UK as well.
Charmaine.
My understanding is that the principles are the same in every intermediate court of appeal in the country. The main difference is in appeals to the High Court, which are a different type of appeal. It's an appeal stricto sensu where the court has to put itself in the shoes of the Court of Appeal and decide what the correct outcome should have been. It can't receive evidence. There are various constitutional limits on what the court can do there. But as far as intermediate courts of appeal go, the principles, to the best of my knowledge, are the same in every Australian jurisdiction.
Thank you. And the other, Tamara, thank you.
Does the panel have any practical tips for practitioners when reviewing a judgment to aid in identifying or advising a client on whether there may be an appellable error?
Well, that's a question which we'd encourage you to look at the notes. Tamara, have we sent the notes around yet?
The case citations were
Yes.
sent, but no notes have been circulated yet.
All right, okay. And are we proposing to send further notes, or?
Roger, I might have an answer to that question. I think the most important thing is to work out what sort of decision it is you're appealing from, and to be very clear about what sorts of errors are actually appellable errors. And so we've set out the 4 different types of decision and what sorts of errors need to be identified for those decisions to be overturned on appeal. But also can I emphasize that the classifications aren't always super obvious, and it's worth researching the particular type of decision that you're proposing to appeal to work out what the standard is. And to give you an example, the courts have power, the family courts have power to alter the interests in a divorced couple in the matrimonial pool of property. Many of you will be familiar that the court can make an order that's just and equitable, changing the parties' property interests. That decision is in fact one which, if you appeal, the full court of the family court will apply the test applicable to discretionary decisions. And you might not think that to be an obvious conclusion, but that's the law. And so knowing that would be of great assistance in actually working out whether there's been an error. And similarly, an assessment of general damages as a common law is also a decision which attracts the discretionary standard of appellate review. And then finally, there are also some decisions where it's in fact not yet clear. And one example of that is where a trial judge concludes that a proceeding is an abusive process. And the current authority in the Court of Appeal of New South Wales is that an appeal from that should also be determined on the test for discretionary decisions. It was recently before the High Court in a case called UBS and Tyne, where all of the court, bar one, left the question open. And so we don't know exactly what the position is there, but the current law is that the discretionary test also applies. So really the important thing is to work out what is the type of decision that you're proposing to appeal from, and what sort of errors are appellable errors for the purposes of that type of decision.
Thanks, Sharma. I mean, I think in terms of the categories that we've discussed, appeals against matters of law are easily identifiable. Appeals against matters of fact, readily identifiable. Decisions involving inferences from facts and so on, evaluative decisions, you need sometimes to, it's a matter of a feel for the decision in some respects, and in particular, there's a grey area between what are classically regarded as evaluative decisions and decisions involving the exercise of a discretion. For example, is a decision on a value of land in Australian law an evaluative decision or a discretionary decision? And I think the authorities would favour the view that is a discretionary decision. Likewise, a decision about the extent of damage, an award of damages, would typically be regarded in Australian law as one of discretion rather than an evaluative decision. So, you need to be aware of that distinction, and you need to be aware of the cases that talk about it. And they are in our notes that we'll send, to the case references that we'll send to you. Justice Gageler referred to the point in Minister of Immigration and Border Protection. Can I just read from that? The line is not drawn by reference to whether the primary judge's process of reasoning to reach a conclusion can be characterised as evaluative or is on a topic on which judicial minds might reasonably differ. The line is drawn by reference to whether the legal criterion applied or purportedly applied by the primary judge to reach the conclusion demands a unique outcome, in which case the correctness standard applies, or tolerates a range of outcomes, in which case the House and King standard applies. The resultant line is not bright, but it's tolerably clear and workable. So I think it's important. I think Jermaine's exactly right that the critical thing is to identify the nature of the decision appealed against. In some respects, there are some grey areas, and particularly between evaluative decisions and discretionary decisions. Once that decision is made, then to apply the relevant test to the facts and the law as you have for you. All right.
Just one final question, Roger. I know one person asked this, and I'm sure quite a few people are interested. What is the picture behind you, and who's the artist?
Okay, well, it's got a bit of a history. I can't tell you the artist because I can't read Russian. But when the Iron Curtain came down in 1989, there was a flood onto the European art market of Soviet paintings, political paintings. And they were typically large, and they bore characteristics of sort of Soviet nationalism. And this is a depiction of the Soviet invasion of the Kuril Islands at a time, I think, between the First and the Second World Wars. But you can see it's totally idealistic and unrealistic. You can see how the combatants have caps on and are carrying small bags which look like medicine bags and things. They don't really look like real soldiers, but I don't think that was the purpose of the painting. So I can't tell you the artist. It was painted before 1989, and it's by a member of a citizen of the Soviet Union, or what was then the Soviet Union. I bought it, incidentally, Judge, at an auction in London, where there was a lot of those
Roger,
paintings.
send me a picture. Send me a picture of the signature. I'll try and get it for you, because I think.
All right, thank you.
I can transliterate Russian into our script.
Oh,
I can't
I'll do
speak
that.
any of it anymore.
Well,
Thank you very much.